Court of Appeals Division 1 is now in session.
Good morning. Thank you. You may be seated. We're here this morning in CACV 140393, Wade versus MHP number 3. Each side will have 20 minutes to present argument. Appellant will have an opportunity to reserve any rebuttal that you'd like to reserve. You'll be responsible for doing that. We'd ask you to identify yourself and your client for the benefit of the recordings that are being made, where these proceedings are being both audio and video recorded. We have read the briefs in this case. In the record, we've conferenced this matter already, so we do have an idea about what the issues are. And we look forward to your argument. With that, Counsel for Appellant, you may proceed.
Good afternoon. May it please the court. My name is Christopher Graham. I represent Appellant Robert Brian Wade, and I'd like to reserve 4 minutes for rebuttal, but I will try to be brief in my case in chief here. The issue before the court is really what happens to title to a mobile home after the death of a tenant. What happened in this case is that a putative lien was placed on the mobile home for failure to pay rent. And then a landlord lien sale was had, changing title from the estate of Norma Mae Wade to the Appellee Contempo Tempe Mobile Home Park. I think Judge Coffey initially got this right in his April 2013 rulings when he held that lien cannot exist due to ARS 33361, and that statute holds that a lien shall not secure the payment of rent occurring after the death or bankruptcy of the lessee. The threshold issue then in this case is going to be whether that statute applies or not. It is our position that it does, and that's governed by ARS 33381, which first, and we can pull up 30-year-old Senate fact sheets, but the best indicator of what the legislator's intent was is going to be what's written in the statute.
Counsel, let's assume for a second that you're right and that the mobile home then goes into Ms. Wade's estate, which is then subject to claims of her creditors, which is, I understand from the record here, were significant and far exceeded any alleged value of this property. How is your client in a position to benefit at all, even assuming Judge Coffey's first ruling was correct?
Well, he does have an interest in it. He is an heir, and he is a devicee under the will to that property. I don't think we can say at this point that he would have no interest because the probate process didn't allow to go all the way through.
Was there a will? I saw there was a reference to maybe there was and maybe there wasn't.
There was a will. It was a handwritten will that left the mobile home and its contents to Mr. Wade and his brother. Back to your question about what's my client's interest in this, I think we need to let the probate process run its course. Under the probate laws, creditors can reduce their claims. No attempt was done to do that. If they reduce the claims, there may be something left.
Can I ask a preliminary question, though? Isn't this a claim that would need to be brought on behalf of the estate? Wouldn't that be by a personal representative?
And it was initially brought by Mr. Wade while he served as personal representative.
But he was not the personal representative at the time the second ruling came out. Isn't that correct?
He was not at the time of the motion.
Oh, but fiduciary was, and they didn't challenge that ruling.
No, they didn't.
Shouldn't someone like Contempo only be required to deal with someone representing the estate? Do all the creditors have to deal individually with everyone who might have, there are 10 beneficiaries to an estate? Doesn't it make more sense to have a claim be brought by someone acting on behalf of the of the estate?
It does, and I think the beneficiary still has an interest, even though they're not serving as personal representative, and they're allowed to look after their best
But
interests.
how do they
in the
have
estate.
how do they have an interest without being appointed as personal representative?
Because they have an interest in the property. If that property can come out of probate.
But so you're saying any beneficiary can bring claims on behalf of an estate?
I think the law supports that. The beneficiaries with their interest have standing to look at the probate proceedings, overlook what the personal representative is doing, and bring any petitions that they like with the probate court, as we did here.
Wouldn't that be akin to a surcharge against the PR or perhaps a mandamus against the PR as opposed to a separate independent claim with respect to a creditor? I mean, isn't that how the probate system works?
I don't think so. I think there is law that supports a beneficiary filing a petition with the probate court asking for that relief, and I believe that law is cited in my reply brief.
There's a specific statute that allows a beneficiary to pursue a claim against a personal representative if they haven't properly managed an estate. That seems to suggest that the statutory scheme is to have the personal representative go after creditors on behalf of the estate, and then the beneficiaries, to the extent they think the personal representative got it wrong, would try to surcharge or go after the personal representative if there was some basis for doing so.
I think that's an accurate portrayal, but I don't think it's an either or. I think the beneficiary does still have that interest.
But what if there's three other beneficiaries to this estate? Does Contempo have to defend against lawsuits by all three of them? Are the other three beneficiaries bound by what one beneficiary raises?
I think if they're given proper notice, yes. If they're part of the probate proceedings, filing a petition, you have to give notice to all beneficiaries when you file that petition asking the probate court for
Don't
relief.
the beneficiaries assume that there's a personal representative who's managing the estate? They have to get involved in litigation?
They don't have to. They can, just watch the personal representative and abide by the personal representative. But what we had here is when the public fiduciary came in, he just kind of threw up his hands and said, well, this case is done. And Mr. Wade said, no, I've been making these claims and making these claims. And he was finally able to get counsel. And we went in and tried to go back and rectify those claims that were made. And I think we did it the proper process of being able to do the motion to vacate, the ruling on the motion for reconsideration, and asserting it by Mr. Wade as a beneficiary of the estate, or as an heir to the estate. Actually, I think the term in the probate code is interested person, and we can bring that. So, as I was getting back to what I was saying, whether the threshold issue then is whether 33-381 applies, and we need to look at the express language of that statute. And what it says is it shall apply to all landlord-tenant relationships, and it has one exception only, and that deals with dwelling units. And then the term dwelling unit is specifically defined. It's defined to exclude the land that's underneath the mobile home. What we have here is not a rental of a dwelling unit. We don't have a landlord-tenant relationship for that dwelling unit. We have a landlord-tenant relationship for that mobile home space. That's going to fall under the preamble or the umbrella of all landlord-tenant relationships, and it doesn't fall under the exception of a dwelling unit. And, I think appellee has gotten off track by, looking at the dimensions, chapter 11 here. But that's specifically related to dwelling unit. You can't phrase a statute or you can't read the statute to ask or to provide the relief that they're asking for. The legislature could have said it applies to mobile home spaces. It could have said it applies to mobile homes. But they said it applies to all landlord-tenant relationships except dwelling units. And then what does it say? Which shall be governed by Chapter 10 or Chapter 11. And under dwelling units under the Mobile Home Act, which is Chapter 11, is governed under ARS 33-1454, which provides for subleasing, and that's how we have the dwelling units under the Mobile Home Act.
Can I go back to the question Judge Winthrop asked about whether your client is an aggrieved party? Let's say there's a bank account with $10,000 in it. There are creditors who are owed $25,000. What incentive do creditors have? I understand that creditors, if there's a total of $30,000 that's owed to creditors and there's a bank account with $10,000, the creditors realize they're not going to get everything. But what incentive do they have to settle those claims for anything less than the collective group of creditors using up all of the $10,000? Sorry for the long question.
Sure, and I think the answer is, the same reason creditors always settle claims is to.
But they settle claims because they don't think they're going to be able to collect. Here, my hypothetical is you've got $10,000 sitting in a bank account that's owned by an estate, and I have a claim against the estate, and I just know that two other creditors have a claim against that estate. I know that $10,000 is available to me. Why would I be willing to settle for something? Why would I say I'll only take $2,000 of that? What incentive would I have as a creditor to only take $2,000?
Expediency, to get paid right away, to not have to further engage in the probate process. I think that's a valid reason. There could be, things like this where it goes to the Court of Appeals and the creditors, still haven't been paid or would not have been paid if the estate had any assets. They can resolve it and get the expediency of, getting their money or getting what they can, what they agree to, and being done with it. I think that's a real benefit to the creditors. Another point raised by the appellee is if they don't have the right to do a landlord lien sale on a home after the death, after the home's been sitting there, is that it'll just sit there indefinitely, and that's just not correct. The legislature did provide a remedy for them. A creditor can go ahead and open a probate proceeding. So if a mobile home's sitting there, no one stepped forward to run through to be the personal representative and open the probate proceeding. The creditor can't do that. In this case, a mobile home park could come in and say, nobody's taking care of this. We are a creditor. Let's open probate and let's dispose of this asset of the estate. I think what's highly improper about this case is that the Mobile Home Act does have a remedy in it, and it doesn't have to do with title, but it's how you're supposed to treat people after a tenant has died. And what happens depends on whether the surviving person is a co-tenant or whether they're just an heir. Either way, and there's a factual dispute in the record whether Mr. Wade was a co-tenant or he at a minimum is an heir. Either way, that person is going to have the same rights, liabilities, and obligations as the original tenant. What happened in this case is Mr. Wade, after going to the mobile home park manager's office, providing a will, setting up services for his mother, he gets a notice from Contempo Tempe saying, "You are a trespasser, do not pay rent." After that, forcible detainer action, and Mr. Wade was removed as John Doe under the forcible detainer. That's just completely improper. There was no. And Mr. Wade lived there for 7 years prior to his mother's death, and then all of a sudden, a month and a half after his mother's death. They claim to not know who he was those prior 7 years, but they've discovered that he's now a trespasser.
But can they have, are there, I don't know the particular restrictions in this case, but if there's an age restriction in the mobile home park, and if he doesn't meet the age restriction, then are you saying the mobile home park has an obligation to nevertheless let him stay there?
There are certain, there's a statute that says for reasons why they cannot deny a new tenant taking over. But, if it's an age restriction, like on this case, he certainly has the right to continue to pay rent, to keep the asset. And, when they say rent will not be accepted, what's he going to do? And then later on they claim that rent's not being paid, so it's abandoned, and we're going to take title to it.
But could he not have just taken the mobile home from the park initially, after his mother died?
Well, the Mobile Home Act says you cannot remove the mobile home unless all the rent was paid. He wasn't in the financial position at that point until some life insurance to be able to pay off everything. He could still pay.
Was rent owed then before his mother died?
No, the rent was up to that date. And he paid the first month rent, and then he would.
But at that point, so if his mother died, the next week he could have taken the mobile home from the park?
He could have, yeah, under the Mobile Home Act, if everything else would have been up to date. But he got it, in June, a month later, so there was still that month's rent due. If he would have paid that, I guess he could have taken it at that point if he had the ability to not only pay the rent, but to hire somebody, because the Mobile Home Act is pretty specific as to what needs to be done to repair the space and everything. I'm running down to 4 minutes left. I'll stop there.
May it please the court. My name is Mark Zinman at counsel's table. It's my partner Mike Parham. We represent MHP3 LLC Contempo Tempe Mobile Home Park, which, as the courts recognize, the issue we have here is that my client is a creditor that's been dragged through numerous litigations, spending thousands of dollars with a party that it has absolutely no privity with. Before we can even address the issues of 33362 and its application to this case, we need to address those procedural issues which were largely caused by appellant and his failure to follow court orders, repeatedly contradicting himself in documents, and most importantly, his failing to differentiate himself as a person as opposed to the estate. Most specifically, in regards to Judge Winthrop's question, what we had was, how is he aggrieved? And talking about the speculation and the value of the estate. What, if you note, in the reply brief, one of the arguments they have as to why that it should go back down to probate is that the estate may have claims against Contempo. One, this is speculative in nature, and two, that's a claim that the estate would have, that the public fiduciary would have to bring as the personal representative. As you'll note, though, personal representative was never made a party to this appeal by appellant. Therefore, those claims are simply waived. Additionally, as the court is aware, under 143811, a personal representative can bring counterclaims against a creditor. Those are the claims the personal representative has, not the heir. A creditor is not intended to litigate against every single heir that may exist. Think about what would happen if you had a large estate. You could have dozens of beneficiaries potentially and thousands of creditors, and it's expected that a creditor has to litigate with each one separately. It doesn't make sense, and it's not something that's supposed to happen. Now, if we go back to the value of the estate, which I think we can dismiss the appeal summarily on that issue.
Counsel, let me ask you, Mr. Wade is an interested person under the probate law, would you agree?
Under the definition, absolutely, Your Honor.
And what rights does that give him to pursue separate and apart from the rights that the estate could press through a personal representative?
Well, I think that as the court noted earlier, the rights are, obviously, he has rights under the will, but the personal representative is the one that holds the estate. And so the issue is, and this case is a perfect example of it, is if the personal representative makes a mistake, there's a breach of fiduciary duty against them, And that's where the damages issue comes up, and I can explain that in a second. They don't have a right to go directly to the creditor because there's no privity with them. So what happens if you look specifically, if I can address your question with the example of this case, what we have in regards to the value. And appellant's argument repeatedly is, well, it's just speculative what we have, and we want to go back down to probate so it can be fully adjudicated. What he's missing is that it has been fully adjudicated. The personal representative said the value of the single asset is $8,500. The court concurred. The court admitted, found allowable over $21,000 in allowable creditor claims. So those are specific findings. There's nothing speculative about it. What his argument is actually is mislabeled. What his argument is not that it's speculative, it's that the personal representative made a mistake in finding that it's an $8,500 value. Well, that's a claim against the personal representative saying, you know, you should have gone out, you should have gotten an appraisal, you should have done something, and your number's incorrect. But if you recall,
I think he's arguing more that the personal representative might be able to compromise the creditor's claims as opposed to maybe challenging the value of the mobile home.
Well, I think he's raising both issues, but the court's question was actually right on point to that issue. Why would a creditor settle it? The court's already allowed those claims. The court's effectively saying for some of them, which the initial credit claims for a credit card was $14,000. You're owed $14,000. I've got $10,000 to split up between you, 3 parties. How about you guys all just take less? I mean, there's a pile of money sitting there. There's no reason the creditors would settle those claims for less than they're owed.
Well, they're going to have to, aren't they? The estate's not worth that.
Well, no, if there was money left over, let's say,
right,
the court would split it up, saying, okay, this is your portion, and this is yours. Maybe one titled to $3,000, they're saying, okay, this portion's your $3,000, even though you're owed $5,000. What appellant is now arguing is saying, well, yeah, you got $3,000 there with your name on it, but maybe you should take $1,000 anyways.
But let me ask, is your client's claim, which it is valued in various ways, but somewhere around $7,000 at some point in this litigation, are you second to the credit card company?
No, Your Honor, because we have that possessory lien. When our claim was made, when the first order required us to give title back to the estate.
Right.
So we gave title back to the estate and made a claim approximately of that amount. At that point, we have a possessory lien under the Mobile Home Act, and therefore we are first priority as a secured party, and that's why we are allowed to proceed with the lien.
And has that lien amount increased?
Yes, if, for example, if for some reason the estate, if we had to transfer title back, obviously, right now we have title, but if the title went back, that's the underlying issue. This mobile home, a 1979 mobile home, has been sitting on my client's lot since 2012 with not a single dollar of rent being paid. And that's where I think the court's questions to counsel were right on point, which is you have, what remedy do they have? What are they going to do? Is it that he could have, Mr. Wade, when the decedent passed, he could have removed the home. He could have paid rent as an heir. He did neither. His counsel's argument was, well, he didn't have the funds. That's not the park's fault. While we're sympathetic to that issue, it doesn't mean he didn't have remedies. He just personally was unavailable to him. He had a brother, maybe they had and didn't have an interest. All that's speculative. However, he had a right to remove the home. He simply failed to do it, and he's expecting that we would allow this home to stay on our property endlessly without any recourse. Counsel's argument to that, of course, is that, well, you can open probate. Okay, maybe in the 1%, I don't think that's required by the law, and we can address that under 362, but also that's ignoring all of the other mobile home issues out there. In probate, maybe that would potentially work, but what about when tenants simply abandon homes finding that they have no value? There's no recourse for a mobile home landlord without that lien, because we can't do a writ of execution. There's no other means to have that park home removed. So effectively, without that lien, a home would sit on that land forever.
Let me ask, though, and I understand that, but that's in a situation where the title holder hasn't passed. Fair? It's
Yes.
just you can't find the title holder, and there's this asset sitting on your client's property, and you need to deal with it somehow.
Or as well, Your Honor, though, if the owner passed and maybe the owner was living out of Canada, and we have probate, but probate's out of Canada, my client wouldn't have a right in Arizona to probate for personal property.
You could probably open an ancillary, couldn't you, with the real property owned in or at least the quasi-real property.
Well, and that's exactly the issue. If it was real property, absolutely, you could open ancillary. However, mobile home's not defined as real property, so you'd effectively be asking us to open probate in Canada. But the other issue is a lot of times, if the court's not aware, Mobile homes are owned a lot of times just by snowbirds. People come in and out of the state. A lot of them maybe anywhere in the 50 states, maybe in Canada. What the proposition is here is if somebody's gone for 3 months, let's say, and rent's unpaid, we now have to start searching all 50 states to see if the person died, start searching Canada, figure out, well, maybe we should open probate. We can't do it here because it's not real property. What do they do? We need that lien, and that's why the legislature created it. This court acknowledged it in Gulf Homes versus Bayer. That's their recourse. That's their means of ensuring that we don't have vacant, dilapidated mobile homes on their space.
Let me ask you to address Mr. Wade's argument that your client knew of his presence, knew of him, yet he wasn't personally named or served.
Absolutely. I mean, I think one, first off, goes to a credibility issue. Two, the argument is barred by res judicata. We have the eviction action, and that issue addresses whether or not he was a tenant or not, and that it can't be simply reviewed at this point.
Well, and I understand that argument, but I think his argument would be, that's all well and good, but I wasn't joined. You knew who I was. You know, Oklahoma v. Pope says you needed to sort of tell me about this, and you didn't.
Well, Mr. Wade actually appeared at that hearing and made arguments. Additionally, he filed 4 motions to vacate and thus made himself a party. If the court's focusing, I mean, you have it one of two ways. Either he's a party under the case law because he actually litigated the case, or he had no standing whatsoever. He wasn't a party because his name didn't contain the pleadings. Well, obviously under the first case, it's res judicata, right? He litigated the case. It's not just possession. It's all under the court's precedent, under Haywood v. Zoll, it's all other ancillary issues as well, which is, were you a tenant or not, because that's a precursor to possession. On the other hand, though, let's say he wasn't a party. That's basically analogous to what we have here. So if the court wants to find that, okay, he wasn't a party, he shouldn't have filed 4 motions to vacate, he couldn't appeal, that's exactly what we have in the probate case too, right? They're literally identical. Probate, he was the personal representative until he was suspended and ultimately removed. We then had a 4-month span where he's not personal representative. January 30th of 2014, he shows up, files a motion to vacate. Identical to what he did in the eviction. He wasn't a named party, he didn't move to intervene, and now he's appealed, and he has that same lack of standing issue. So if the court holds that there's no standing in the eviction, we have that same issue on the appeal before this court. Or, because he litigated it, he's a party, and therefore he's barred by res judicata from raising those tenancy issues.
Although if you follow those two paths to the conclusion, don't you get to different places? Res judicata, it's done. The other path, nothing's even started.
Well, I think if you take the other path, the issue is this appeal, he doesn't have standing, and it comes back to the court's earlier question, which is, why isn't the personal representative here? And that's the question we can't figure out as contempo, which is, why not bring the personal representative in? The personal representative is the one that said in their August 9th report of investigation, the value is $8,500. We believe there's $21,000 right now in creditor claims. The personal representative, the public fiduciary, went out, saw the home, spoke to Mr. Wade about whether or not there was any personal property that had any value, whether there are any bank accounts. Based on Mr. Wade's assertions to the personal representative, they found that there was $0 anywhere. Whether you believe that or not, that's what the finding was. We could have objected saying that's impossible that somebody doesn't have any value whatsoever. But that's what happened. So they filed a report, the public fiduciary, saying $8,500, $21,000. Appellant's right at that point is to object. There's no complaint or allegation that he was in jail or otherwise unavailable to do that in August. He simply waived that right. And again, that goes back to the fact that it's him objecting to what the personal representative did. And the personal representative is not here, and therefore all of those claims are barred. So the question comes back again to what his argument is and what there's the relief that appellant is seeking. He wants the matter to be fully adjudicated. It has been fully adjudicated. The court's gone through, looked at a sole asset of $8,500, figured out the creditor's claims are $21,000, and said the estate's insolvent. Not a single other creditor objected to that. The personal representative didn't object to that. The only person that objected is an heir who wasn't a party. And so his claim is not against contempo. And as I said when I opened, our argument is we've been spending thousands of dollars, and I'm sure the court can understand, more than the value of the home litigating this case through the eviction, the civil litigation, and now through the probate. The entire process is not set up to be intended that way. And I'll also, in terms of the res judicata and the value, the claims that he has, I will note, in the reply brief, appellant argues that the judgment in either of the two cases is limited to possession and no other issues. Again, we know possession incorporates other issues. So the eviction is not just the word possession, it's ancillary issues as well. Because think about a non-payment of rent eviction, right? You get a judgment. That means the landlord's entitled to possession. But the ancillary part of that also is the tenant breached the lease. That issue is also res judicata. Now, going to the civil case, appellant tries to paint this picture of it was just an appeal. Well, we know that's not a case. Legally, that's not in a case. And then factually as well, it wasn't the case. And therefore, any of the issues that could have been brought in that case or were raised by appellant at that time are also res judicata. Now, what's important, if you look to the civil complaint, which we've attached as appendices, is paragraph 7 of the complaint. It says, the defendants are non-compliant with and in violation of multiple statutes of the Arizona Landlord-Tenant Act and the Mobile Home Parks Act, including but not limited to 33-1452, and then he cites numerous statutes, which is, if you notice, those same statutes are permeated through the brief in this court. As well, under paragraph 8, it says, defendants have conspired together to commit fraud against the plaintiff to gain title and ownership by fraudulent means of the plaintiff's personal property, parentheses, dwelling unit, mobile home. That means in the civil litigation, it's not an issue of just possession. He was trying to raise those same claims of fraud, title. If the court, and what appellant's arguing is that in a minute entry, that the court limited its ruling just the fact that there was an appeal. Well, that's correct. But the order wasn't limited in any way. And two, he raised it in his pleadings. So if the court ignored those allegations and improperly dismissed his complaint, his remedy was to appeal it. He didn't appeal it. 2 weeks later, he filed a probate and entirely changed his argument. If the court recalls, in the civil litigation, he attached a copy of his will saying that he and his brother, Stephen James Wade, were both the heirs to the estate. And that was in August. 2 weeks later, he decides to open probate, claiming there was no will, and two, that he's the sole heir. And those are the kind of the things that go to his credibility. And the court's earlier question of, how did they not know who he was? All we have before the court is the fact they didn't know who he was. Anything else, again, it goes to mere speculation. What I'd like to just address last, obviously, is that landlord lien, which we've touched on. As a court, we provided to the court in a supplement, the second supplement, 33-362 addresses the death after a tenant's death and that there's no lien can arise. Clearly, the 33-301 section does not apply to mobile home statutes. There's an entirely separate statute act dealing with manufactured homes. If the court looks to the legislative history, in addition to the fact statement that I provided, what you have is 381 was created legislatively in 1973. It was the same time that the Residential Landlord-Tenant Act was passed. What we had before that was just the commercial statutes, what's now known as the Commercial Landlord-Tenant Act. So when they branched off and created laws just for residential, they passed 381 saying, okay, this applies to everything except for dwelling units under Chapter 10. A couple years later, 1975, the Mobile Home Act is passed. That creates the rights, as the legislature noted, they're individual rights just in mobile home spaces. And ultimately, as we had in our supplement, in 1983, the legislature went back and clarified some of the issues. One of those things was adding the words Chapter 11 into 381. There's no way that 362 can apply to the Mobile Home Act. The appellant's argument legally, it renders some of the language superfluous. You have two readings of the statute, which is appellant's argument that it's dwelling units under Chapter 10 and dwelling units under Chapter 11, or simply it's dwelling units under Chapter 10 plus Chapter 11 as well. Well, if you look at appellant's reading, as the court I'm sure is aware at this point, there is no such thing as a rental of a dwelling under Chapter 11. So to argue that basically means the inclusion of it, Chapter 11, in 381 renders that language superfluous because it wouldn't exist. That type of right a dwelling unit under Chapter 11 never exists. And therefore the language would be rendered meaningless by appellant's argument. What is more logical, of course, which is you have a rental of a dwelling under Chapter 10 and all of Chapter 11 does not apply, which makes sense. You have general commercial statutes, residential landlord-tenant act statutes, and then the Mobile Home Park Act statutes. And under the Mobile Home Park statute, you have a landlord lien. There is no requirement, no prohibition regarding death. And that's the other argument that the appellant's making is saying, well, isn't it general versus specific? Well, yeah, there's a general in the commercial, doesn't apply to death, and then it has a prohibition regarding death. And under the Mobile Home Act, there's just a lien. There's no requirements whatsoever that they can do it. And that goes back to the earlier conversation regarding the fact that a mobile home park has no other recourse but that lien. Otherwise, those homes would sit derelict condition on my client's property and thousands of other mobile home parks throughout the city. In Gulf Home versus Bayer, this court recognized the fact that there is a landlord lien, saying that did not exist prior to the statute, and now a lien exists. The legislature implicitly agreed with this court's holding, because I said in Gulf Homes, which was decided in '79, after that, the legislature went back in '83 and added additional provisions to the Mobile Home Act, cleaning it up. And what they did, they didn't repeal Gulf Homes, they actually added additional statutes, 1451, 1485-01, all creating that exact same lien that existed before this court in 1478 in Gulf Homes. Simply acknowledging the fact that the landlord lien does exist by law, and they have that because a mobile home park would have no other recourse. Briefly, and I'll just address also the request for attorney's fees. Appellant has requested attorney's fees under 34101, arguing that there's a contract. Again, it's at best a disputed fact, but we don't have that issue before this court. There's no document, there's no contract between the two parties. The contract, of course, was between the estate, which what the personal representative has, as well as Contempo. What you have at best is his argument, oh, well, I had a lease. But if the court actually looks to the document and the record before it, the first time, which is we've attached as appendices, appellant did not argue that he had a lease. He had argued that he had been in the property, and his exact arguments was that his mom told him on multiple occasions that she put me on the lease agreement as an occupant when I moved in with her, and I tend to believe her over any of the shiesty lawyers speaking legalese, swearing on a stack of Bibles. Then 2 motions later, he goes, oh, no, I have a lease, I signed one. There's been no evidence of it. I mean, it's unbelievable that in the 3 years that we've been litigating this case, there's been no proof of anything brought forth. Also, so anything else would be the personal representatives. We have sought attorney's fees under 12349 for the fact that we have been dragged through the mud, spending thousands of dollars litigating with a party that we have absolutely no privy with. The claims legally are without support. His factual arguments are simply inconsistent and contradictory, and we're unfortunately being punished because of an heir to a property. Therefore, no other questions. I'm out of time. Thank you, Court.
Thank you. Just to address a few of the things, and I kind of had an epiphany on the court's prior question. The question was whether Mr. Wade could remove the mobile home park after his mother's death, and the answer is no, he can't, because he wasn't the owner of it. He would have to go through probate to get title to it or become personal representative. Then he would have the ability to collect that property or to take ownership of that. So at that point, when they're sending their nasty letter, you're a trespasser, don't pay any rent, he didn't have the right to remove that whole home because he wasn't an owner of it at that point. He was merely an heir. It belonged to the estate. It needed to pass to him or have the personal representative take control of that. Also, to address the standing issue, Mr. Wade wasn't the personal representative, as the court noted earlier, when the motion to vacate was filed in the probate court. There was no address. They didn't even bring up the issue of standing, that he was not able to file that motion to vacate or was not able to make those arguments at that time. I think they're waived at this point because they weren't addressed below and they weren't considered before the probate court. Also, they rely heavily on Gulf Homes, and what this court said in Gulf Homes is that the statute that says that a mobile home may not be removed without all of the rent being caught up or all of the other charges being caught up is akin to a possessory lien. It doesn't say it is a possessory lien. It doesn't say you have the right to sell that property under a landlord lien statute. I think the reliance on Gulf Homes is a little misplaced. Regarding res judicata, we have two cases. One is the Justice Court action that was filed against John Doe. Mr. Wade did show up, but he was not allowed to argue. He did file 3 motions to vacate, and if you look in the appendix that appellee provided, written on one of the denials of the motion to vacate is Robert Brian Wade is not a party to this action. Going to the Superior Court, the rule was, whether it was a timely appeal of the Justice Court action. That was the only issue addressed, is whether it was a timely appeal. As we know, the case law is very clear that title is not addressed in a forcible detainer action. I don't know what they're talking about, ancillary issues, but there's specific law on point that says title is not addressed in a forcible detainer action. Also, the reason why the personal representative is not here, they had not been appointed yet as personal representative when the motion for reconsideration was ruled. They came in after that point. They did make a judgment as to value before that, but they were not personal representative. They did not file any briefs in the motion for reconsideration. They didn't do
The public
anything.
fiduciary, I thought they were, you're saying they were not the personal representative at the time the motion to reconsider was filed?
Correct.
But they
Mr.
were the personal representative when the court ruled on the motion. Is that right?
I don't believe so. I believe they were appointed after that. They were personal representative at the time the motion to vacate was filed. There was a period there after Mr. Wade was dismissed and the public fiduciary was brought in, and they gave some opinions.
I'm sorry,
as
the
to
motion to
value.
vote, the motion to vacate is what was filed by Contempo.
Contempo filed the motion for reconsideration. We filed the motion to vacate.
Okay. But the personal representative was at least functioning at the time the court had those motions.
There was no personal representative appointed at that point. And I'm out of time. Thank you.
Thank you both for your arguments. We'll take this matter under advisement and issue a decision in due course.